Hello, I'm Dr. David Uretich, a lecturer in law at Royal Holloway, University of London. Violet Smith was 17 when she married 21-year-old farm labourer Reginald Woolmington on the 25th of August 1934. On the 10th of December, Reginald shot her through the heart with a sawn-off shotgun in her mother's house where she was then living. When Woolmington was arrested and charged with murder later the same day, he said, "I want to say nothing except I'd done it, and they can do what they like with me. It was jealousy, I suppose. Her mother enticed her away from me. I'd done all I could to get her back. That's all." At trial, however, Woolmington pleaded not guilty, claiming that the gun had gone off by accident, when he showed it to Violet where he was actually threatening to kill himself if she did not return home with him. Woolmington was tried first at the Somerset Assizes at Taunton in January 1935, but when the jury failed to agree a verdict, his case was sent for retrial at Bristol Assizes. At the conclusion of that trial, the judge, Mr. Justice Swift, directed the jury in the following terms.
A charge is made against Reginald Woolmington, the prisoner at the bar, of wilful murder. It is said that on the morning of December the 10th, about 9:30, he murdered his wife. That she died whilst he was in that house, you will, I should think, have little doubt. It is a matter entirely for you. If you accept his evidence, you will have little doubt that she died in consequence of a gunshot wound, which was inflicted by a gun which he had taken to this house and which was in his hands, or in his possession, at the time that it exploded. The Crown has got to satisfy you that this woman, Violet Woolmington, died at the prisoner's hands. They must satisfy you of that beyond any reasonable doubt. If they satisfy you of that, then he has to show that there are circumstances to be found in the evidence given from the witness box in this case which alleviate the crime so that it is only manslaughter, or which excuse the homicide altogether by showing that it was a pure accident.
The second jury found Reginald Woolmington guilty of wilful murder, and he was convicted and sentenced to death on the 14th of February 1935. He subsequently applied to the Court of Appeal for leave to appeal against his conviction. His application was refused, but the Attorney General decided that the case involved a point of law of exceptional public importance, and that in his opinion it was desirable in the public interest that a further appeal should in fact be brought. The appeal against conviction was heard by the House of Lords on the 4th and 5th of April 1935. I'm now joined by Katie Broomfield, a researcher in the History Department at Royal Holloway, University of London, to find out more about the exceptional point of law of public importance that was decided in this case. Katie.
It was whether or not Mr. Justice Swift had erred in his direction to the jury that the burden of proving that Violet Woolmington's death was an accident lay with the defendant. As Reginald Woolmington's barrister explained, however the matter may have been regarded in former years, at the present time the criminal law rests on the foundation that apart from statutory enactment to the contrary, the prosecution must prove the guilt of the prisoner.
And so how was the matter regarded before this case?
It wasn't until the 18th century that barristers acting on behalf of parties in criminal proceedings first articulated the idea that a person was innocent until proven guilty, most notably William Garrow in the 1780s, who was famous for his incisive cross-examination of witnesses in criminal cases. Of course, it wasn't until the 18th century that barristers were enabled to appear in criminal proceedings, and even then they weren't allowed to speak on behalf of their defendant clients. The system developed over time until we arrived at the accusatorial system that we have now.
What is this accusatorial system?
In the accusatorial system, both parties are responsible for gathering and presenting evidence in support of their own position before a neutral judge or jury. In civil non-criminal matters, it's also known as the adversarial system.
So then, in this case, what did the House of Lords decide as to whether Mr Justice Swift had made an error when he directed the jury in Woolmington's case?
The House of Lords found that the jury had been misdirected, and the Lord Chancellor Viscount Sankey explained that actually
the accused is entitled to show by evidence or by examination of the circumstances adduced by the Crown that the act on his part which caused death was either unintentional or provoked. If the jury are either satisfied with his explanation or upon review of all the evidence are left in reasonable doubt whether, even if his explanation be not accepted, the act was unintentional or provoked, the prisoner is entitled to be acquitted.
Well, how could an experienced judge like Mr Justice Swift get the law so wrong?
He actually hadn't got the law wrong. The direction that he gave was a direction that was given in all murder trials at this time. And he was quoting from a treatise from 1762, which set out that
in every charge of murder, the fact of killing first being proved, all the circumstances of accident, necessity, or infirmity are to be satisfactorily proved by the prisoner, unless they arise out of the evidence produced against him. For the law presumeth the fact to have been founded in malice, unless the contrary appeareth. That has been the law of this country for all time since we had law.
That is why this case is so important and is remembered for Viscount Sankey's famous statement that
throughout the web of the English criminal law, one golden thread is always to be seen, that it is the duty of the prosecution to prove the prisoner's guilt. No matter what the charge or where the trial, the principle that the prosecution must prove the guilt of the prisoner is part of the common law of England, and no attempt to whittle it down can be entertained.
Woolmington and DPP guaranteed for the first time an important protection for those accused of a criminal offence in England and Wales. That a person so accused is to be presumed innocent until proven guilty. This important right is now protected in domestic and international law by Article 6 of the European Convention on Human Rights, which secures the right to a fair trial and explicitly states that everyone charged with a criminal offence shall be presumed innocent until proved guilty according to law. Why is this such an important right? Firstly, as Viscount Sankey argued, if it was permissible for a judge to rule that the prosecution had established its case and that unless the defendant could prove his innocence, the jury must find him guilty, it would be the judge deciding whether or not the defendant was guilty, not the jury, which is contrary to the common law. Secondly, where the state is responsible for bringing proceedings which can result in deprivation of a person's liberty, or worse, it is only right that the burden of proof should fall on the prosecution, and that the standard of proof should be a high one. It is not for the accused to prove his or her innocence, but for the prosecution to prove his or her guilt beyond reasonable doubt. An appropriate direction now would be to tell a jury that they must be sure of the defendant's guilt. As Sir William Blackstone, a leading jurist, wrote in 1765, "It is better that 10 guilty persons escape than 1 innocent suffer." Just days before he was due to be hanged, Woolmington's appeal was allowed and his conviction was quashed.